Is time really on your side? It's no secret that having good IP can give you a huge edge over your competition. But how long do trademarks, patents, and copyrights, trade secrets, really last? Hey everyone, I'm JD Hoovener, USPTO patent attorney and CEO here at Bold Patents Law Firm. Today I'll be talking about how long the different forms of IP last. First, let's start off with what the 4 different types of intellectual property are: patents, trademarks, copyrights, and trade secrets. First off, patents. Briefly, what are they? Well, patents are about inventions, right? Patents protect utility and design inventions, all right? Those are 2 different forms. Utility inventions are what makes it functional. If you've invented a new invention that has a functional benefit, you're going for a utility patent. And that gives you 20 years of protection from the date of first filing. Now, it might take 2 to 3 years to get through the patent office. And so once it gets granted, you've got that 17 or 18 years of lifespan. Now for design patents, right? Design patents protect just what something looks like. You get 15 years of protection after the grant. So really it's not that much shorter than the utility patent sister. Now, second, trademarks. Trademarks are those brands, right, that we all know of. Think of Nike and Adidas and, Nordstrom, these big brands that they're familiar and they evoke emotions. What's powerful about brands is that they last as long as the company does. So technically, they last forever. As long as the company's around, the brand is around. Now, what can happen though is sometimes brands get genericized. This has happened to, this sort of famous list of names like Kleenex, right? Pass me a Kleenex, or can you Xerox that for me, right? Make a copy. Or when you go to an airport or some other, company's lobby, you see a scrolling set of staircases and you say, oh, there's the escalator. Well, escalator used to be a brand of movable stairs, okay? But it became known as the actual thing itself. So companies need to be careful that their brands don't become genericized. And so companies like Band-Aid have made certain to call themselves Band-Aid brand. So you know that it's a company behind it, not the actual article itself. Copyrights. So copyrights protect an artist, right? An artist that comes up with their own mind, their own creation, a certain, representation. The only requirement for copyright is it actually has to be fixed in a tangible means, meaning you have to be able to record it somehow, whether it's, a song or it's a artwork, right? It's on a canvas, or it's a publication, a writing. It's got to be stored and either digitally or in physical hard copy so that it can be fixed and it's knowable. And you have the ability to prevent anyone else from making copies of that without your permission. As soon as it's pen put to paper. Registration for copyrights allows you a de facto legal principle. It's called the prima facie evidence, meaning before a judge you don't need to go back and prove who wrote it or who was the artist, when they did it, and what it contained. That's all preserved in the Copyright Office once you have it registered. The duration for a copyright is 70 years plus the life of the author. So the author, the artist passes away. The rule is that they get 70 years of additional rights to allow their heirs to fully benefit from their predecessor. The potential rationale and policy reason for this, oftentimes with art, it takes a long time sometimes for people to realize the real value and the beneficial nature of their creation. And so it's not just when the original artist dies, it's their life plus 70 years. Trade secrets. So what's funny about trade secrets is that, kind of like trademarks, is they can also last forever, so long as the secret remains a secret. In order to have a trade secret, 3 things have to be true. Not known by the general public, you have to be making efforts to keep it secret, and it must be economically valuable to a competitor, right? Those 3 things, right? Not known by the public, you're making progress toward keeping it secret, or you're making efforts to keep it secret. And the third is that it's economically valuable. So those elements combined mean you've got a trade secret. And as long as that is the case, technically you can have a trade secret forever. And that's why many companies and inventors decide, you know what, this is not something that's going to be easily reverse engineered. And so instead of seeking a patent on my recipe for Coca-Cola, I'm going to keep that in-house. And that they have done, right? For over 100 years, nobody quite knows how they make Coca-Cola. And it's lasted for that amount of time, and it will continue to be a trade secret, a valuable protection for anyone that has parts of knowledge or the entire knowledge of that secret method or process. The only real problem for them may be is that if employees decide to leave the company and start their own company and misappropriate those trade secrets or steal them. Last but not least, there's also this category of privacy law within intellectual property. And so I want to bring up briefly this concept of image and likeness. Image and likeness is most important for those famous individuals. And for those people, they have the ability to prevent others from making copies, making money, in essence, commercializing their own image, right? And so photographs, movies, even cartoon impressions of their likeness are impermissible, meaning you cannot simply use that, for example, that well-known Michael Jordan slam dunk image, the silhouette that Nike licenses from the Jordan estate. That's recognizable as Michael Jordan, his slam dunk. That's his likeness. It's actually different than trademarks. It's certainly not patent related. It's not copyright, nor is it trade secret. It's his image and likeness. And so you can actually have a separate realm of intellectual property related to the way you look. Another good example is Colonel Sanders, right? His face is on the front of the building because it's more of his likeness. It's not necessarily having to do with the brand. It's him as an individual. So it's a way to extend the intellectual property beyond the trademark itself to actually calling upon an individual's rights. And that's another way to benefit. The duration, to allow there to be more time that can be controlled by the company. So I hope you enjoyed this lesson of how long patents, trademarks, copyrights, and trade secrets, and images and likenesses can last. I'm J.D. Hoovener, CEO and Managing Partner here at Bold IP. We're here to help. So if you have questions, if you thought through and you listened to this video and you're still scratching your head with something wasn't quite clear, put it in the comment below. We'll be able to get back to you as soon as we can, and we'll give you that feedback that we're hoping for. I hope you enjoyed this video. Make sure to grab our free book and schedule your no-cost consultation today. All right, everybody, take care and have a good day. Go big, go bold.